Call the second case on this morning's docket, number 115441, State of Kansas v. Kendom Danshaw Owens. This is a word of caution. The first case took an hour and 10 minutes to argue. Mr. Maloney, there is no need to consider that a personal record that needs to be broken in this accident.
Wanted to be avoided, I would say.
All right, thank you.
May it please the court, Clayton Perkins appears on behalf of Mr. Kendom Danshaw Owens. I would request 2 minutes for rebuttal.
2 minutes is granted.
In way of the brief procedural and factual review, in February 2012, Mr. Davis, Nathan Davis, was robbed at gunpoint of his car keys and car. Shortly thereafter, Mr. Owens was arrested on the robbery. He was identified by Mr. Davis, which is an identification that he has disputed but is not directly at issue in this trial. In August of 2012, Mr. Owens was waived to adult prosecution. Thereafter, his case was continued a number of times at the request of his appointed defense counsel without his presence or consent. In June of 2013, there was a hearing on his motion to have new counsel appointed and dismiss his case for violation of his speedy trial rights, at which point they basically set his case for a jury trial, and that jury trial occurred in September of 2013. He then, after the trial, filed another motion on his speedy trial rights, and this is a direct appeal from that jury trial, although at a delay because of an Ortiz process and the lack of a notice of appeal originally being filed stemming from the sentencing.
Just to clarify, from the time that Owens was arrested, he was detained either in juvenile detention or an adult facility?
Yes. And that brings us to it was a direct appeal to the Court of Appeals, and then this is a petition for review on one of his issues, which is constitutional speedy trial. And this is basically under the general and case-specific analysis of the Barker v. Wingo factors, which I'm kind of going to just go through one after the other, and both my petition and the state's cross-petition were brought up to these. So the four factors are, of course, the length of delay, the reasons for delay, the assertion of rights, and prejudice. The first factor, length of delay, both the state and I dispute in different ways. The first thing is the time framing here, which he was, again, arrested, and the time between his arrest and trial was about 19 months. The Court of Appeals, in their opinion, said that the only time that matters for constitutional speedy trial analysis was the time between the waiver to adult prosecution and the trial. To do that, they rely on the Myers case out of Arizona, and in my petition and the 609 letter, which I am blanking on whether it's the Roberts or Robinson case out of the Court of Appeals, I've addressed the analysis that is, the Court of Appeals said Mr. Owens wasn't accused under Sixth Amendment reasoning until the adult prosecution. And I don't believe that is correct under the In Re LM opinion and the extension of the jury trial rights to juveniles. If there's a question about whether or not he has a jury trial right, and with that it's a speedy and public trial or a speedy public trial, depending on the federal or state constitutional right, he has that right as part of the jury trial rights already, and I think that is fairly straightforward. He was the accused from the time of his arrest in terms of the constitutional rights. The Myers, as I looked at it further, I am not even sure it's entirely on point, because that I think is distinguishable, that it did not appear that that defendant in Arizona was even arrested on the case they were discussing. He was arrested on other things and then eventually charged as an adult. But I believe that part is, if we're looking at the length of time is 19 months. Regarding whether or not that is presumptively prejudicial in terms of length, I believe the Court of Appeals basically did that analysis correctly, which they looked to what the case was, the complexity of the case, what is basically the expected length of time for that case. And this case was unusual. It was within the time frame that triggers further constitutional analysis. The state's cross petition addresses this as they didn't look further into the peculiar circumstances of that case, of this case, but as far as that goes, it seems to me like it's basically asking us to look to the other Barker v. Wingo factors in order to determine whether we look to the other Barker v. Wingo factors. Regarding then the second factor, which is where there's the most dispute, reason for delay. And this is delay that is triggered off of defense continuances. And normally there's sort of a presumption, I think, with defense continuances that the defendant has acquiesced to those, the defendant has consented to those. Hopefully the defendant has been consulted by their counsel about those. That is not this case, and that is the main problem in what went on here, particularly between his waiver to adult prosecution and the hearing where it got addressed for the first time in June. There wasn't contact with counsel to begin with. He wasn't appearing. He wasn't brought to appear. He didn't have the opportunity to object to any speedy trial rights he had and enforce those between both statutory and constitutional rights. He needs to be objecting, and he just wasn't there and wasn't even, at least it didn't, I don't believe it was ever disputed. He wasn't even in contact with his defense counsel during that time. So there was just, it seems to me nothing going on in this case except this juvenile was being held in jail for 8 months. And I think that is problematic, and I understand that it is not deliberate malfeasance on the state. They weren't trying to delay this, and there are, in fact, 3 parties in the courtroom, the defense, the state, and the court, that are all responsible to guard the right to speedy trial, but that just wasn't happening here. And so I think in terms of reasons for delay, that is attributable to the state at the end of the day.
Counsel, maybe you can help clarify something for me. This, on the issue of who was causing these delays and how long the delays were, the overall delay. In May of 13, the defendant moved to dismiss his lawyer, wanted to get a new one, and it was basically because of the fact that his lawyer had gotten about 10 continuances, and he said he wasn't aware of it, and it wasn't with his consent. The matter comes up for hearing in June, the following month, and at the hearing, he agreed to withdraw his motion on the condition that his lawyer would set the case in either July or August, in other words, just a couple months down the road. Now, what do we make out of that? Is he somehow tacitly waiving his speedy trial rights at that point by saying, oh, it's okay just so long as I get a trial in a couple of months? I know this has been delayed for all this time, but I'm willing to set all that aside if I can get this case tried.
No, I don't believe it is. And there's sort of 2 parts to that. One was, even at that hearing, it was sort of discussed as contingent. Are you withdrawing this? You can raise speedy trial later if there's still a problem, but we'll set the case for trial. And that's, I think...
Okay, I didn't see the transcript, but that was discussed then.
It was briefly discussed there, but I think also relevant to this is that it was his options then were to possibly get, a trial quickly from that point, or to delay his speedy trial even further because it would require the appointment of new counsel and all of that. So he's kind of set up with a Sophie's choice of what to do then. And I think that timing is also really relevant in that hearing seems to be the point where someone says, okay, can we actually go to a trial? And everything that is discussed in terms of what defense counsel was doing for plea negotiations, for trial preparation, was occurring after that point. So with this particular case, they were able to basically actually go to trial within 3 months, when it had just been sitting for 8 months in there. And part of the Court of Appeals analysis in this was that he had requested a plea, negotiation way back at the September 2012 meeting with his defense counsel, and he didn't get the plea and wasn't able to reject the plea until July of 2013. But again, when we're talking about length of time here, that is a period of 10 months or so where apparently the only thing going on is that he had told his counsel, can you see if there's a plea?
You say apparently. I mean, was an attempt made to flesh out what was going on, what the back and forth might have been between the state and defense counsel or anything else?
It's not really. The state at the sentencing hearing mentions a little bit of the procedural history. His appointed counsel mentions a little bit of the procedural history. And then we have his pro se motions, which include a great deal of the procedural history, but they kind of talked past each other. They acknowledged that on May 22nd, the state and defense had talked about a plea. There's no discussion as to what went on before that. There's no denial that they weren't in contact throughout that entire time period.
And so whose burden was it to flesh some of that out? I mean, we can't just really just rely on an assumption of what was going on, can we?
Not generally. This is falling into sort of a weird window here that some of the cases like Wright and I believe Brownlee fell into, that there isn't much of a record of any of this because a record wasn't being made. His defense counsel wasn't arguing for his speedy trial rights at any point in this. She didn't argue for any of the motions related to this. It was all the defendant's pro se motion, and defense counsel just briefly discussed the facts. And so he was asserting his right, but there was no one arguing it an evidentiary matter to sort of put on the evidence for some of this.
Could you go to the fourth Barker v. Wingo factor before you run out of time?
Absolutely, and that is prejudice, and there's prejudice relating to sort of the inherent things referenced in Barker, which is delay, which is anxiety, which are all of those problems, and which are all present here. Particularly, you have a juvenile pending this adult prosecution that will, as it turned out, impact the next 17 years. Specifically to this case, however, it ties back into the eyewitness identification, and that this case basically all comes down to that identification. And in the particular circumstances here, the passage of time impacted the eyewitness's ability to recall, which allowed for basically a playing off of the inconsistencies between how he described the person who robbed him and Mr. Owens in that.
Excuse me, the victim's testimony is what you're referring to, is that right?
Yes, it is. Did I?
No, you didn't specify.
Oh, I apologize. Yes,
Because there's an officer who testified as well, correct?
Yes, there was an officer that testified, although the officer, I don't recall if he actually identified Mr. Owens. He testified that he saw someone with jeans running. But primarily this comes down to Mr. Davis's identification because he's the one who said Mr. Owens was the one that robbed him.
Even though Mr. Owens' cell phone was found in the car?
Even though Mr. Owens' cell phone was found in the car, which, again, Mr. Owens' testimony and the defense argument has been that Mr. Owens was the victim of basically the same robbers who stole his property, which is why it was in the car. With that, I would request that you reverse the Court of Appeals and enforce his constitutional speedy trial rights.
Do we have any further questions? Thank you, counsel.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. Obviously, the speedy trial issue is the only one before the court today. And just to clarify, the cross petition that we filed was simply because we wanted to make sure that the Court of Appeals opinion doesn't just go for the proposition that in any case where there's a limited number of witnesses and the trial does not take a long time, that automatically means that a case is simple and therefore should be able to go to trial quicker than you would normally anticipate. We're not focused on the facts of this particular case, but we didn't want the case to be read for the proposition that in analyzing the first factor and whether there's presumptive prejudice, whether the time period is lengthy enough to trigger the other factors, that you simply go through and you count and you say, well, there were only 2 witnesses and the transcript only comprised of 60 pages of testimony. There are obviously a lot of factors that go into any given case, and we would simply ask this court to recognize that, and in any situation where you're asked to address the length of the delay, take all those factors that in any given case may be on the record and evaluate those. My concern was that this panel seemed to cite Weaver and simply indicate that, well, there were only a couple witnesses and therefore under Weaver this was a simple case and the time period was presumptively long enough to trigger the remaining factors. Turning to the factors in this case, the length of delay.
Can I clarify, you're not saying then that you disagree that in this case it did trigger the factors?
Oh, we don't know. We don't think, we're not conceding that, and that gets to a point raised by counsel. I think this court's case law, it is somewhat, I don't know if confusing is the right word, but in the analysis of the length of delay and whether that does trigger the other factors, there is case law, and I've cited it in my brief, that in determining whether that factor triggers the others, that you do take into consideration not just the amount of the delay, but what caused that delay. So that in a situation, for instance, let's say there's a case where a defendant personally is requesting continuances over and over and over again, and that ends up leading the case to being delayed for 2 years.
But isn't that the second factor of
It
Barker?
is, but I'm just quoting back this court's own case law to it. The Davis, I believe Davis is the case that I cite for that proposition that indicates that you don't, and that makes sense. If a defendant is personally in court every Monday saying, I want a continuance, and he does that for 2 years, and the court grants those continuances, then it would seem a little illogical to then say, well, we've got this first factor triggered, so now we have to go through all the other factors. So to that extent, that would be why we're not conceding that first factor in this case, because I think that the most important thing I want to emphasize today is that we're here on a case in which there were 10 continuances requested. The state requested exactly 0 of those continuances. So in a situation like that, our position is that no, the defendant should not be able to get past that first factor. And in constitutional speedy trial analysis, the U.S. Supreme Court has said in a case, I believe it's called Vermont versus Brilliant, that basically for constitutional speedy trial purposes, that only in very, very rare circumstances, I think probably something along the lines of ineffective assistance or maybe a conflict, something of that nature, would a defense counsel's request for a continuance not be charged to the defendant, even if he didn't know about it. So in this situation, while it was the defense attorney that was requesting all of these continuances, our belief is that the length of delay does not rise to the level that you have to again analyze the remaining factors. Of course, I will address those factors. The second factor being the reason for the delay. And I would dispute, I think counsel has indicated that the record is less than clear as to the reason for the delay. Our position is that it actually is very clear. I think on page 11 of the Court of Appeals slip opinion, they discuss the fact that at the hearing on his motion to dismiss, defense counsel explicitly stated that because of ongoing plea negotiations, she had to request several continuances. The prosecutor confirmed that. The defendant, who was sitting there both at the pretrial hearing and at the post-conviction hearing when he was arguing about this, he never alleged that his attorney was misleading the court about the plea negotiation process. And in fact, in his pro se motion to dismiss, he had confirmed those statements by saying that he had asked his attorney to enter into plea negotiations. And so this is a case where the record is clear. The case was continued by defense counsel because her client had asked her to negotiate a plea. There was also the fact that he wanted her to try and get this consolidated with another case. That took a while. And then counsel also indicated that her client wanted her to investigate potential witnesses, but that he was slow in getting her the contact information for those witnesses. So we have all sorts of explanations for why this case was delayed, and they refute his assertion that counsel was continuing this case without his knowledge. He had in fact asked her to do those things. She was requesting the continuances in order to effectuate his personal chosen strategies.
So it might be true that he didn't authorize the continuances directly, but you're suggesting if the continuance requests were caused by his urging her to do specific things, then he's nevertheless responsible.
Right. And I think perhaps maybe the record would be somewhat unclear to the first point, whether he was specifically authorizing them. I do note that in his original brief, he never did allege specifically that had he been present in court for the continuance hearings that he would have objected. He simply noted that he had not been present, but it was not a case where he said, and if I had been there, I would have objected. But even if he had made that allegation, I think the record as a whole shows that he, in fact, was at least tacitly authorizing these. The third factor is the assertion of the right. He first mentioned this in his May 2013 motion, which was 15 months after he had initially been arrested. So he didn't say anything about this for 15 months, and he then withdrew that motion when he had an opportunity to come in front of the court and argue it. And he then did not complain about it again until after he had been convicted. So the Court of Appeals seemed to indicate that this factor weighed in the defendant's favor. I would argue otherwise when he waited until 15 months to assert it, and then he immediately chose to waive it and not bring it up again until after he was convicted. Finally, turning to the fourth and final factor, the prejudice prong. As the panel noted in its opinion, he was in custody on other charges for the vast majority of the time that this case was pending. So this is not a situation where he can say that had this case been tried sooner, that he would have been out of custody, and that it's only because of the delay that he had to deal with the oppressive incarceration leading up to trial. The other prejudice that he attempts to cite is the victim's memory of the incident and the identification. I would agree with the Court of Appeals that the record actually shows that the victim's description was consistent from the time of the incident all the way up through trial. I think there was maybe one occasion where the victim's memory had to be refreshed while he was testifying, but I would say that that's a far cry from the victim not having a memory of the incident, or from his testimony somehow changing in a way that would prejudice the defendant. And as I argued in the brief, and as the Court of Appeals also pointed out, To the extent that the victim is unclear on details, and let's say there's a case where he truly is unable to provide good identification testimony at trial, that would actually hurt the state. It's the state's burden to prove the identity of the assailant. And if the victim at trial is unable to do so as reliably as he otherwise would have been because of the passage of time, that does not hurt the defendant. That actually helps him because it makes it more difficult to prove the identity of the attacker, the assailant.
What does prejudice to the defendant mean then?
Well, certainly in certain cases, I think there can be, perhaps if there's a defense witness who would have been able to offer.
Are we limited to considering prejudice as it impacts the verdict?
Well, no, because it does take into account things like oppressive pretrial incarceration. Now, I think the case law says that generally the impact on the defense is the most significant of those factors, but the prejudice factor does encompass other things, such as pretrial incarceration. So, of course, if there's a case where there's somebody who is not in custody on other charges and is solely left to sit in jail for fill in the blank, 2 years just sitting in prison.
That can count as prejudice as well.
Yes, it can. Yes, it is one of the factors that's included among prejudice. And again, in this case, it certainly weighs against the defendant because he would have been in custody regardless on his other case. So to sum up, our position is that none of the factors actually weigh in the defendant's favor, and the only reason that we filed the cross petition is just because we want recognition of the fact that sometimes simply looking at the transcript and how many pages it is and how many witnesses testify doesn't always reflect the fact that there might have been more pretrial preparation than would otherwise be indicated. If there are no further questions, we would simply request that
I think we have a question here.
I'd like to
Sure.
focus on when do we start counting the time? Whether we include the time he's in juvenile detention.
And honestly, preparing for today and in light of the Robinson opinion and In re LM, I think that the state would be hard-pressed to say that in a situation like this, where the charges were the same, I would say it's hard for the state to say that the time spent in the juvenile case shouldn't be added in. I think even in situations where somebody's charged in adult court and then the case is dismissed for whatever reason and refiled in a new case, in that situation, the case law indicates that you'll essentially look to see why that initial case was dismissed. If it was done out of necessity or if different charges were filed, then you don't necessarily add in that time back because it's essentially a different proceeding or it was something that was unavoidable. But I think that probably the same analysis should apply in juvenile to adult context. And here I don't think that there were any different charges that were filed in adult court. So based on these particular facts, I think I would concede that probably the 6 months that he spent in the juvenile system on these identical charges probably should be included in the analysis. But again, that's not to say that in any case where somebody is originally charged as a juvenile that you would tack that on. It would depend if additional charges were filed or if there were some other reasons that maybe would necessitate not counting that time. But in this particular case, I think that's the 19 months is the reasonable time to consider.
Any further questions? I think we cut you off as you were wrapping up.
Now, I was just going to say, if there aren't any other questions, our position would just be that the Court of Appeals panel was correct in determining that there was not a speedy trial violation.
Thank you, counsel.
Thank you.
Thank you.
There are just a couple of points I'd like to address regarding what the state said there. First, regarding way this was argued, I argued in my brief that these continuances were obtained without Mr. Owen's presence and consent. And in the way I say consent there, if he's not consenting to it, he's objecting to it. The consent is sometimes deemed by acquiescence, but I did not think it was ambiguous that someone who is not consenting to something is not agreeing to let it happen. And Mr. Owen, in his own words, on Volume 1, page 44, in his pro se motion on this speedy trial issue, says he would have objected. Quote, if she had asked me to do so, I would have objected to it, regarding waiving his speedy trial rights. And Mr. Owens asserted as much as possible his rights because he was not present at all of these hearings, so he didn't have the option to assert them. And in fact, as he mentions in his motion, he tried to file the motion before, and it wasn't filed, it was sent to defense counsel even before the June hearing. Regarding the plea negotiations, Mr. Owens didn't dispute that in September of 2012, he talked to his attorney about plea negotiations. And his defense counsel says in Volume 7, page 14, but that's why the continuances were taken, because we were trying to resolve the case by consolidating through a plea offer. And I don't think there's a dispute that he did request plea negotiations. The issue is that this reached this unreasonable and absurd level of nothing actually happening with any of that. No, it does not appear any plea discussions were occurring. He didn't talk to his counsel before then, and I believe that is all.
I had a question. My recollection of your opening presentation was you felt there was prejudice to your client because the delay caused the victim's testimony to be hazier than what it might have been, let's say, a year earlier.
Yes.
And you said that was prejudice to your client, and then the state turned that around and basically said, well, gee, that's prejudice to us, helping the defendant because it's the state's obligation to prove that your client committed the crime. Can you address that difference of opinion?
Yes. And I think, and partially this comes down to the nebulous nature of fading memories, which Barker v. Wingo kind of addresses as why prejudice is such a hard thing to attribute in speedy trial. But my argument is that because his memory faded, and particularly there was both a identification, a show-up identification that was suggestive in my opinion, and he was also shown a photo of Mr. Owens after his arrest, and he's testifying to all of those. His memory basically lumped all of those together. So who he saw robbing him got lumped with who he saw in the photo that was provided by the state, which got lumped with what the robber was wearing versus what Mr. Owens was wearing. And that the fading memories helped the state in this, in that he could no longer distinguish those. Oh, well, it's been a year and a half. Okay, well, but he's the guy I ID'd, and they were basically relying on that, if that makes sense.
Very good, thank you. Do we have any further questions? Thank you, counsel. Thank you both for your arguments this morning. Clerk will take this matter under advisement